Hello, everyone. Hello. I'm Elsa W. Smith, your Maryland estate planning attorney, and I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Welcome to Women Winning Wednesdays. Through our guests and educational content, my hope is to give you a glimpse of what an empowered woman is and the tools that you need to win. As a reminder, we're streaming via StreamYard, and I need you to give StreamYard permission to give us permission to see your comments. And say hi. Let me know that you're here. Tell me where you're listening from. And by the way, if you catch this on the replay, make sure and put hashtag replay in the comments so we know that you caught it on the replay. So today we're here answering your questions. Keep in mind before we get started that the information I give is informational and for educational purposes only, and it's not meant to be legal advice. So now that I got the disclaimer out of the way, we're here to talk about or to answer your questions. And thank you so much to the people who submitted questions to questions at elsawsmith.com. elsawsmithlaw.com. We do read those questions, by the way. Now, during today's show, you are welcome to type in questions or comments in the chat. But I want to focus on a couple questions that we got that are, I thought, questions that, because I get them so often, I figure that many of you have the same questions. So I wanted to start off, but at least addressing those. So the first question, I'm going to put it on the screen, is where should I store my will and other estate plan documents? That's a great question. And it's a commonly asked one. Now, what I want to do is to kind of take a different tack. I want to tell you where you shouldn't, and then kind of back into the places that you might want to consider for storing your will and other estate plan documents. So where should you not store your will and other estate plan documents? Well, a dresser drawer, for example, a coffee can. And if you're old school, this is really going to resonate with you. An empty Crisco can above the stove. Yes, I said it, and I'm not ashamed because I know there are some of you that know exactly what I'm talking about, the old Crisco can. Or under a sofa cushion, a la the late Aretha Franklin. Or just any other place in your home that is exposed to fire, floods, or even tampering. Someone can come, people come in and out of your home and find that will or other important document, and you may not want them to. So it's not really a secure place to leave documents. Another place that is probably going to surprise you is a safety deposit box at a bank. I really don't recommend that as a place to keep your will and other important documents. Why? Well, if you die and no one knows that you had a safety deposit box, or no one knows where the key is, you're going to have your loved ones are going to have a problem. And as a matter of fact, they're going to need a court order in order to access that safety deposit box. And so at first, the idea of a safety deposit box sounds like it makes sense, appears like it would give you the security that you're looking for, but at the end of the day, it might add cost and inconvenience to those that you leave behind and who are already going through a stressful time as a result of your passing. So what about at an attorney's office? Again, not my preference. Now, having said that, I am aware that some firms keep vaults in their offices with their clients' original documents. Now, that practice of safekeeping wills at the lawyer's office. It came from a time when most people didn't have a secure place to keep wills and other important documents. But now, I mean, think about it. People buy home safes. They have other secure storage options. So you certainly are not limited. And there are probably even better options than keeping it at an attorney's office. Now, let's go down that path for a minute. If your attorney is willing to and presents that as an option, and if you think that that is the right option for you, what I need you to ask is ask them if they have a written policy covering the retention and then the disposal of client documents and files. And then ask them how those documents are going to be stored and where. Ask them also, how is your personal representative going to get access or be granted permission to access those documents? That should all be written out. And of course, if you decide to go that route, you actually have to tell your personal representative that you are keeping your originals at your attorney's office. Again, not something that's widely used anymore, as far as I can tell, because people nowadays have so many other options. But again, you want to ask those questions of your attorney or of the firm before you choose to make that as your storage option. Another option that I'm really not a fan of is on your own computer. Not a good choice. Okay, scanning important documents and storing them on your computer is probably, not the best idea. Why? Because as most of us know who have computers, they crash, they get viruses, they get hacked, and all of your information can be lost. Now, unless like I said, you don't want to keep them on your computer's hard drive. However, there are cloud-based services, such as iCloud and others. You certainly can do your due diligence and research what cloud-based options there are to store your documents. And you want to make sure that it's a secure option that prevents them as much as possible from being hacked or, giving thieves access to your important documents. So I talked a bit about where you shouldn't keep your documents, in my opinion. Where should you? What are some good options? Well, for our clients, we recommend that they store their original will with the Register of Wills in their county. And in Maryland, there's a minimal fee. At the moment, it's $5 to register and store your will in the vault with the Register of Wills. So it is really easy to do. I highly recommend it. And for my clients or former clients who are listening, I trust that each one of you has stored your wills at the appropriate Register of Wills office, because it's one thing that we talk about throughout the representation. And on signing day, that's a reminder that I give my clients. Now, I just said that you can store your will at the Register of Wills office, but what about the other documents that you'll likely have, like a trust or a power of attorney, an advance directive? If you're going to keep them at home, you want to consider like a fireproof safe or a locked filing cabinet, for example. If it's a place, a location that is going to require a combination, you want to make sure that someone that you trust knows how to access it or knows where to find a key. For our clients, we provide a scanned copy of all of their documents on a flash drive, which we provide with their portfolio. You want to keep the flash drive in a safe place too. but at least that, at least having them on a flash drive gives you at least a copy of those documents. Now, I talked about cloud options a couple seconds ago. As I said, there are a number of options, Dropbox, Google Drive, Microsoft OneDrive, and you can also keep them on an external hard drive. Now, if you decide to store your estate planning documents on your computer, or on a cloud-based service, make sure that it's encrypted. And what I mean by that is that you can lock out anyone who's not authorized to access those documents. And you want to share the password to get to those documents. You want to share that password with your personal representative. Some places around the country call it an executor, but in Maryland, we use the term personal representative. That's who you'd want to know how to access these important documents. And at this point, let me ask the audience, where do you keep your estate planning documents? Do you have a safe, maybe in a home office somewhere? Is it in a locked cabinet? Are some of you, I'd love to, see in the comments, like, where you all keep your documents. Are you still using the safety deposit box option? Now, of course, I'm not really a fan. However, at least since we're talking about it now, maybe I've given you something to think about. It's okay to have items in the box. However, make sure that some responsible person knows or has access to that box if, heaven forbid, something should happen to you. I've just seen it happen too many times to folks that pass away and no one knows where anything is. And if it's in a safety deposit box, they can't get access to it. So that's really, that's really a nightmare option. Yeah, absolutely. Fireproof lockbox at home. Yeah, that's great. That's great. So now, thank you for that comment. Now I want to go on to our next question. Like I said, these are really great. I'm going to post it up here. Here we go. I'm having a hard time choosing someone to handle my affairs when I die. What should I do? Boy, does this one come up over and over and over again. It's so important because that question could be like the biggest hurdle in someone getting started with an estate plan because they don't have anyone that they can trust. Now, if you have no family members or friends that you are comfortable with, underline comfortable, appointing as a personal representative in your will, you can appoint what's known as a corporate trustee to handle your estate. Now, many banks and financial institutions, they have that as an option. They have a corporate trustee who will manage your estate for a fee, of course. But another option is that you can have the corporate trustee to work alongside a family member that you identify in your will or trust to manage your assets. Like the person that you appoint, maybe a family member or a friend, can handle the personal property, and then you can have the corporate trustee manage the financial assets that may be a bit beyond the skill set or the comfort level of a person that you name to handle all those other things. And it's okay to do that. But I wanted to share that with everybody, that a corporate trustee, keep that as an option, in the back of your mind as you're thinking about, who to put in these important roles. The corporate trustee, they're regulated by law, and they have a fiduciary responsibility. That means that they've got to look out for your interest, right? They've got to ensure that your wishes, as you've written them out in a will or in a trust document, that they are carried out. And they're also obliged to act in the best interest of those of any beneficiaries that you've designated. So keep that corporate fiduciary possibility, in mind. Now, I want to add a follow-up, because when I saw this question come through, um, a twist to this question is, well, what if you have a few people in mind, but you're not sure if they're a good fit for a particular role? Now, I've addressed that issue in webinars that I've done and articles that I've written on my blog, on my website. And that focuses around the concept of putting the right people in the right roles, right? So let's say, practical example, you are a mom and you have little ones, right? And you want to, you want to name, you need to name a guardian, okay? But you've got a few people in mind, but you're not sure if they're really qualified to. What should you look for? Well, first of all, let's think about what a guardian is. That person is really going to step in your shoes to rear these children, to raise these children. So think about, is this the kind of person that I want around my kids? Is this the person, can they model my values, my traditions, my beliefs? Or are they going to be able to honor those so that my kids are raised the way that I wish? Do your kids already have some sort of, a good relationship with this person? Does this person even like kids? Okay. I mean, let's be real. There's some people that just don't have the skill set or the patience to deal with kids, at a certain age. Something else that you want to think about when you're thinking about guardians is the person in a point in their life where maybe they're ascending in their career and they've got to travel quite a bit, and they're not going to be at home. They're not going to be in one place. So think about that. And if you've got minors or, or pre-teens, for example, you're going to need someone that's going to be there, for them. If you have a person who is, up there in years, they're elderly and they've got some health challenges, with all due respect, that may not be the ideal person to name as a guardian for your children, because if something happens to that person, then what, right? And if you don't have a successor guardian or a backup guardian, if you will, if that makes it easier to understand, then you're going to have a problem. So you really need to think carefully and be intentional about the person that you choose to put in that role. Let's look at another role, say a power of attorney agent, right? Somebody that during your lifetime, because as we know, the power of attorney is only effective during a person's lifetime. Who do we know? Who do we trust? First of all, it needs to be a person who's trustworthy, a person who is responsible. This person is really going to be stepping in your shoes when you are incapable of handling your affairs. When, if you're in the hospital, for example, this person is going to be interacting with banks, with investment houses. If you have to buy or sell property, if you are corresponding with maybe the IRS or some other, government agency regarding benefits, is that person going to have the right temperament to manage your affairs responsibly until, you can get back on your feet? If there are some people who may be really nice, but let's say if they're bouncing checks all over the place, if they're really irresponsible, and they really just have what you'd call kind of like a sketchy lifestyle, that may not be the person that you want in the role of really any role, but particularly the role of power of attorney agent. So think clearly about putting the right people in the right roles. And before we even start that conversation, I want people not to start considering those roles from a place of guilt, like I owe someone a role in my estate plan because they are my sibling, because they are my aunt, uncle, whoever, godparent, whoever. You don't owe anybody anything. All right. And I'm going to say it once and for all. You don't owe anybody anything. This is your estate plan. And it just frustrates me because I know that that's, that guilt that people come to my office with, like, they have 3 kids, 3 adult kids, and they want to, give them all a role. Well, if Susie and Johnny are irresponsible and Mary's the only one that's got a good head on her shoulders, then guess what? Then Mary is probably going to have at least one or more roles. It's not about appearances, and it's not about guilt. It's about being responsible and not leaving a mess behind for those you leave behind. Not leaving a mess for those that you leave behind. So I tell my clients, if you want to paint me as the bad guy and say, well, my attorney suggested X, Y, Z, go right ahead. Because I would rather you do that and come out with an estate plan that you are confident in, that you've made, with just certainty, and that you leave with a sense of empowerment. I would much rather you do that than to create documents out of guilt. And I never recommend that to any of my clients. And I actually advise them to just, step back. If they're in that guilt space, then we need to have some serious conversations until, we can get you out of that guilt space, because that's not healthy at all. So enough of me on my soapbox, but I'm really passionate about that because I care about my clients and I don't want them to make just bad decisions, right? Let's see if we have any questions. Okay, we don't, but I did want to mention, you've been seeing on the ticker stream since the beginning of the webinar, an ad for our free webinar. It's called How to Put Your Mask On First, Estate Planning for Today's Women. Now, what am I talking about? I'm giving you tools in that webinar to start considering, what your estate plan is going to look like. I talk about the reasons that we as women need to be intentional about our estate planning. Let me get that. It's not selfish to make a plan for your own incapacity. It's not selfish to plan for what's going to happen to your kids or with your kids when you die. In fact, it's one of the most selfless things that you can do, when you're of sound mind, when you have a clear head, not in crisis mode, but that you actually take the time and plan things out, not just for after you die, but a quality of life while you're still here. So I want you to go to my website at elsawsmithlaw.com. elsawsmithlaw.com. It's right there on the homepage. Register for that webinar, and there is a special offer for everyone who attends the webinar. So I want you to take advantage of it. My mission is not only to educate, but to empower. And the webinar is just one example of the free content that I am putting out there for you to consume. Where else can you get free content? Visit my YouTube channel at Elsa W. Smith Law. Subscribe, and that'll let you know. You'll be aware of, like, anytime that we put out new content, which right now is about once a week. You'll see free videos on estate planning and other topics that are going to benefit you, and you can access them at any time on your phone or on your desktop. So feel free to do that too. Let's see. Here we go. If you have questions about how to get started with your estate planning, I want you to give our office a call at 410-995-7719. I'm licensed in Maryland and the District of Columbia. You can also follow me on social media. Many of you do already. Thank you so much. At Elsa W. Smith Law. I'm on Facebook, YouTube, LinkedIn, Twitter, Instagram. You can find me there as well. Let's have the conversation. You know, it's time. For many of you, you know that you need to take care of your estate planning, but you've been putting it off. You've been procrastinating. Make this the month that you make the decision to make the call, sit down, let's have a strategy session, and let's plan out what your legacy is going to be. I'm going to check one last time to see if we have any questions, and we don't. I really want to thank you for joining me today on this episode of Women Winning Wednesdays. Again, we read your questions. So submit your questions to questions@elsawsmithlaw.com, and perhaps, we'll address it in a future episode. But I want you to know that we are listening. We're here for you, and we want to give you the most up-to-date and just practical information that you can use, like right now. I want to thank you for joining me this week. I'm Elsa W. Smith, your Maryland estate planning attorney. I'm looking forward to seeing you next week on the next episode of Women Winning Wednesdays. Have a wonderful day, everyone. Take care.